All right. Good morning. I'd like to welcome everybody to the March 1st meeting of the Arizona Weights and Measures Council. Going to go ahead and call the meeting to order, and we'll turn it over to Kevin for a roll call.
All right. Good morning, everybody. I'm Kevin Allen, the Associate Director for the Weights and Measure Services Division. Hope you all can hear us okay. It looks like we're sounding okay. We'll do a roll call of the council members, starting with Lynn Hamilton.
I am present.
Okay. Michael Mathers. All right. Mark Ellery.
Present.
Leah Siggety.
Present.
And Eric Edelin.
Present.
All right, Mr. Chairman, we have 4 council members present. I believe we have a quorum.
Okay. Move on to the approval of the December 13th meeting recording. We did have that recorded. I believe we went back and got everything that had been missed at the beginning. Do we have a motion to go ahead and approve those minutes?
I'll motion to approve.
I'll second.
All right. All in favor of that? Say aye.
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 Any opposed? Nope. We'll go ahead and approve the minutes as they were recorded from the December 13th meeting. Okay, we'll go ahead and move on to number 4 on the agenda and turn the time over to Kevin.
Okay, so the next item on our agenda is to go over the updated rules in Arizona Administrative Code Title III, Chapter 7. So if you recall, we were going through a rulemaking. The rulemaking process has been completed. Our rules actually go into effect on Sunday, March 5th. So they go into effect 60 days after the date that they're published in the Administrative Register. So they were published, the 60 days after the date that they were filed with the Secretary of State's office, I should say, because they weren't published until February. But they were filed with the Secretary of State's office back on January 4th. And so what I'm going to do this morning is just briefly run through the rules, just to go through and solidify this is what has been adopted in the Administrative Code, and just talk about any major changes. I know we've went through these in the past, but just some people may think, oh, well, something didn't go through or that didn't go through. I just want to make sure that everybody's aware of what's coming up. I will start off by saying for rules related to motor fuels, cleaner burning gasoline, E15, our division is holding 2 workshops in April that are virtual on April 5th and April 19th to answer any questions about those rules. And it's just relating to motor fuels, cleaner burning gasoline, E15, because that's the bulk of the changes that were made, and that's the most complex portion of the rule. So we did send out an invitation to that to our registered suppliers who produce CBG for us, as well as those signed up for our motor fuels distribution list on the listserv. If you are interested in participating in those meetings, just send an email to dwm@azda.gov or contact me directly, and we'll make sure that you get the link to attend those meetings. But all they are just workshops to answer questions, and both of the workshops are the same. So if you attend one workshop, you don't have to attend the other unless you want to. There may be some different questions asked at both, but we're going to provide an overview of those rules at that time. So any questions about that before I get started? All right. Let's see here. Okay, I'm going to share my screen here. Okay, so everybody should see what was submitted for the notice of final rulemaking up on the big screen here. And I'm still showing the version that has the strikeouts and underlines because I want to emphasize what changes have been made. Obviously, the final rule that gets published in the administrative register, the strikeouts and underlines won't be there. It'll just be a, consistent text going forward. So I'm going to go through here and just cover, like I said, the most significant changes. And feel free to ask any questions along the way. But we'll go ahead here. So Article 1, our definitions. The first one here that I will point out, administrative order. This was updated. The definition used to have 8 different scenarios here that defined what an administrative order is. And that definition was broadened to just if you have a violation of our statutes or our rules, an administrative order is a notice that orders a person to take corrective action and may include hold or removal orders, our warning, out of service, stop sale, stop use tags. So really the administrative order can cover anything. If there's a violation and we tell you, hey, you need to correct this, that's an administrative order. And that can be done through our enforcement tags as well, the red, yellow, and blue ones. So that's all that it's doing. It's just broadening that because there was a little bit of confusion in the past on, even from our own staff, on what an administrative order was. And now it pretty much covers anytime we say, hey, you need to fix something, that's defined as an administrative order. Let's see here. And I will skip over some of them that are just, editorial clarification types of things. One of these that I thought was interesting here, the definition of a day. In our rules, there are times where you have to submit a document within a certain number of days, or you have to report to us information within a certain number of days. And one of the things I found out was that if it's not specified as a business day, typically by default, it means a calendar day. And this goes for, I guess, legal documents all over the place. And I didn't know that. But what we did is just defined, if the word day pops up, we mean a calendar day unless we specify otherwise. And there's a couple of scenarios where business day is specified, but typically it's just days. So going through our rules, if you see 7 days, that means 7 calendar days, not 7 business days. So something like a placed in service report needs to be submitted within 7 calendar days, for instance. This next one applies to registered service agencies and representatives. There was a lot of terminology for field calibration standards, the equipment that's used to certify the accuracy of commercial weighing and measuring devices. And so we just combined all of that terminology into one name, field calibration standard. And so when we refer to a field calibration standard in the rule, we mean that equipment that you use to certify those weighing and measuring devices. And so it has the same meaning as secondary standards, which is defined in our statutes, but includes all the test equipment that a registered service agency or representative might use, such as weights, weight sets, measures, meters, counters, other devices for use by RSAs and RSRs to certify the accuracy. So we did that just to make things consistent throughout the text of our rule. And the big part of it here is for an RSA and RSR, if you're using that equipment, it needs to be certified under through our state metrology laboratory under our statutes, which either means that you need to have it certified at a NIST traceable lab, and that certificate needs to be on file with our lab, or our lab needs to perform the certification on their own. That's not a new requirement, but it just emphasizes that, hey, this equipment needs to be certified. You can't use it if it's not. Handbooks, NIST handbooks, we've adopted, I would like to say the most recent edition, but they have 2023 versions now of each of these. We weren't able to adopt those ahead of time. So we have adopted the 2022 editions of NIST Handbook 44, 130, and 133 is the 2020 edition because there wasn't a 21 or 22 edition. And now there's a 23 edition of both. But we have to adopt a specific edition by statute. And so 2022 for Handbook 44, which is the specifications and tolerances for commercial devices, this is adopted in our statutes and is really It's basically the law in Arizona as it applies to commercial weighing and measuring devices. So all of those requirements in there, commercial weighing and measuring devices in our state have to comply with those regulations. And then Handbook 130 relates to method of sale, packaging, and labeling. We adopt that in our rule. And then Handbook 133 are the test procedures and the tolerances for packaged commodities. And so we use that when we go out and test items sold by weight, count, volume, whatever. There's specific test procedures in there for certain items, and then there's general test procedures for others. That is the standard that we use to perform our inspections and check to see if a package meets its labeled quantity statement.
Kevin, do you mind, how much difference is there between those different? I mean, I understand that the
Yeah.
changing of one word means that you have to adopt a new one, but is it, you would think that after a certain amount of time, I mean, just curious.
It depends on the section in the book. Sometimes there are significant changes to it. For instance, like in the 2023 Handbook 44, the tentative code for electric vehicle charging stations is now a permanent code. So that's a big change. But then there's sometimes a lot of small changes, kind of like we do with the rules, where a clarification is needed. There's confusion amongst the regulators on, well, what does this exactly mean? And the benefit of it is that anybody, if you're ever looking at a requirement, a code in the handbooks, you can always go back and look at the National Conference on Weights and Measures reports, because it'll say when it was adopted, the year that it was adopted, or the year that it was amended. And you can go back and look at the reports and see what they meant by it at that point in time. There was one recently where we had that same question, and so we had to go back to, like 1973 and look at the NCWM report and go, oh, that's what they meant by it, and then it makes sense. But sometimes somebody will go, that's a significant enough, room for interpretation that this needs to be addressed at the national level, and they'll go and they'll submit a proposal to change the handbooks, and if they're adopted, then it'll be adopted in the most recent one. But the nice thing about the handbooks is that if there is amendment made, it'll give you in parentheses at the bottom the year that the amendment was made. So for instance, if you're looking at the 2022 edition of a handbook versus the 2018 that we used to have, if you see anything that says amended 2019, 2020, 2021, it might be worth looking into that change and going, okay, what's changed since then? Sometimes it's minor, sometimes it's not, but it just depends on the year. There's a lot of different proposals moving through NCWM right now relating to cannabis, e-commerce, propane, all sorts of things. And so it's important to keep track on that. We try our best to do it. We send our compliance managers to NCWM twice a year to participate in those meetings. So if there's ever any question about what's going on at NCWM, we can always connect you with the right person to help answer those questions. And just one moment here. Okay, so moving on here. This one here, retail price inspection. This is a new term that we're hoping to adopt in the future for our actual inspections that perform for price posting and price verification. So we're just going to call it one inspection, retail price inspection. And so what we did ahead of time is added that terminology in there. It means the inspection of a retail location for compliance with retail price posting or retail price verification. The reason that we want to combine those is because both inspections happen simultaneously. And so the way our current database is designed, it treats them as two separate inspections, but in reality it's one. And so to hopefully improve efficiency in reporting and documentation in the future, that's a new definition that we have there, retail price inspection, a new term. Let's see here. And the other definition I'd like to point out here is vapor recovery test equipment. So like the field calibration standards, there were different terminologies used to describe this new term, vapor recovery test equipment. And it's basically the same thing, but it's for registered service agencies and representatives that perform work on vapor recovery systems. And so it's all test equipment such as meters, measures, counters, other devices that are required for use by RSAs and RSRs to verify the performance of vapor recovery systems and are certified according to carb test procedures, manufacturer specifications, or this chapter. So things like a manometer or a test stand for a PV vent valve, for instance, that meets the definition of vapor recovery test equipment. And so when we refer to that later in the rule, particularly Article 6, that's what it means. Okay. There are just some editorial changes in 103. 104, this one had a big change. So this is our administrative enforcement action. And you'll see as I scroll forward, there was a lot of text that was stricken out. It used to have specific situations and specific civil penalty maximums and enforcement actions that could be taken. And now what it is it's just brought in to say, hey, if you violate our chapter, our rule, any of the handbooks that we adopt, or CARB executive orders, we may do any one of the following or the combination of the above. So it says that we may issue a warning, out of service, stop sale, stop use tag, or another administrative order, and it cites the statute that gives us that authority. Seize or condemn a seal of authority, weight measure, or other commercial device, cites the statutes that give us that authority. Impose a civil penalty, cites the statutes that gives us that authority. Revoke or suspend a license under 334.72. Utilize appropriate progressive enforcement action, which that is incorporated into our statute. And what that means is, you know, if it's a first violation for a location, you know, the first instance of it happening, we're not going to apply the maximum that we can. We're going to start small, and it might just be an education. It might just be a time frame to correct. It might not be a civil penalty or placing a device out of service, something like that. But that the appropriate progressive enforcement action is, okay, if you don't comply with our first administrative order, that corrective action notice, then, okay, maybe we will shut down your device. Maybe a civil penalty is appropriate at that point. And if then you fail to comply with that one, okay, it increasingly gets higher and higher. And it's that's what the progressive enforcement action means. And that's part of our policy as far as how we apply enforcement action, how we apply civil penalties. Typically, we give people a chance to make things right, or we'll start off small with the enforcement action. But if it repeats or it becomes a systematic issue, then we have to go to the next level. And then number 6, like I said, implement any combination of the above. So we could do an administrative order with a civil penalty. That often happens, for instance, if we find a device that's out of tolerance and it's measuring in favor of the device owner. So we'll place the device out of service. 1, it remains out of service until it's recalibrated. And 2, that typically comes along with a $300 civil penalty. And that's been our policy for a long time. And our policy for issuing civil penalties and the amounts, that isn't changing. This just gives us the authority to use different levels of enforcement action where it's appropriate, especially if you have those instances of repeated noncompliance where we try to work with a location to get back on track and it's just not happening. Then B, this was reworded a little bit, but it just says the division may inspect or examine premises, equipment, or relevant records to determine compliance with our statutes, rules, and so on. We already had the authority to do this. It's just clarified here. I'm just going to check on something really quick. Here. Mute. Let's make sure everybody's muted there. Okay. And then it does show that if a person does not comply with our inspection or examination requests, it can be considered a violation and we can take enforcement action off of that. Rarely do we have that happen, but every now and then somebody is like, no, I don't want to let you in. And then we've had instances where we actually have to go get go to the local courts, and get a document that says, yep, like a special inspection warrant to let us in. But we already have the authority to visit most locations without that. So again, rarely do we have to exercise that authority. And then this last one here, this was already written into 104. It's just being called out separately because it's such an extreme case where if somebody buries a vapor recovery system before we're allowed to do a pre-burial inspection, which is part of the authority to construct permit when there's work being done underground, we could require a person to excavate that system so we can inspect it. Again, since I've been here, we haven't had to do this. Usually we're able to resolve it without requiring excavation, one, because it can be very expensive and time consuming, but that remains in here if we need to, for whatever reason, confirm that the vapor recovery system is constructed as it was approved in our permit, then we have the authority to have somebody excavate it.
Hey, Kevin,
Yes.
on letter B,
Yes.
I noticed that they've striked through the email notification. That's still in place though, right?
It's still in place. Yeah, it's required in Title 41 that we have to provide a copy of the inspection report within 30 days, I believe.
Okay.
And so we do that by email, although I believe just by publishing the inspection records online in our database, that satisfies that requirement, but typically we'll email it within that time frame. So yeah, so that was removed mainly because it's already covered in statute.
Okay.
There were some instances. One of the things I learned is that a lot of the times you don't want to repeat what's in statute because the statute may change and then the rule stays the way it was before, and then they conflict with each other. They're not consistent. So that's why that was done. And that was done elsewhere where the statute already says this. And in Title 41, it seems like for our regulatory Bill of Rights, for instance, the requirements for what is on our regulatory Bill of Rights, it seems to change every year. The legislature adds something to it and the text gets smaller and we add another page to it. Right now, our regulatory Bill of Rights is 2 pages. We're hoping we don't ever get to 3 pages because that's what we hand out at the beginning of our inspections. But Title 41, a lot of our inspection procedures, things we have to do, are listed out in there for the different state agencies. So as we go through, you can see all the text that's been stricken out here in 104, and it had a section for each type of inspection that we do, and now it's just all under one general section. So go through here, 108, editorial, down through here. 109, this was moved from 104 and combined with the text that currently existed. But basically it says a person who is adversely affected by an action made by the division. So for instance, if we issue a notice of violation, may request a hearing to dispute license denial, inspection results of violation or enforcement action under Title 41, Chapter 6, Article 10. So, anything that we do as far as enforcement action is concerned, people always have a right to request a hearing for violations, request an informal settlement conference. If you feel that action was unfair, it was not justified, things like that. That formal process is written under Title 41, and we can go through that. Fortunately, we haven't had to go to a hearing in many years, but it is something that somebody is more than welcome to request, and we'll act accordingly. And then 110, I'm not going to go through that. Motion for rehearing or review, but there's updated language in there. It's mainly just clarifying language. So, all right. And so then we get to Article 2, commercial devices. Not much has changed in here, but we did add for all of our licenses, so commercial devices, public waymaster, registered service agencies and representatives, we called out separately here that if your business name changes or the address changes, because we've had businesses where they moved down the street, for instance, we need to be notified within 30 days of the change. A lot of times we'll go out to a location and nobody's there anymore. And we find out that, oh, yeah, so-and-so, they moved down the street, down the block, whatever. We just need to have that notification. It's kind of like with your driver's license. You have to report a change of address within 10 days. It's just to help us keep track, so we know where you are, where the devices are, where the business is operating. And of course, we don't charge a fee to process the change in business name or address. It's usually pretty easy. Just send us an email and say, hey, my business, this is the account, I moved here. We can update it really quickly and we'll confirm that with you, and then all is done. So we appreciate when people are proactive and they reach out to us, but that is a requirement for all of our licenses now.
Quick question on that, Kevin.
Yes.
Is it the same email address you noted before? DWM
DWM.
at
Yep.
AZG. Excellent. Thank
Yeah,
you. sir.
DWM at azda.gov. That's our general, it goes into our management team, and then we typically can assign those conversations to an individual for follow-up. And then if you change ownership, you do need an application to transfer a license. So if it goes from person A to person B, our licensing department needs a new application to transfer that license. And we have a change of ownership form that needs to be completed. And it just helps us smoothly transition, because if it's a fuel station, for instance, and you have all of these devices, let's say there's 24 pumps that need to be transferred over to a new person. Before, we would have to manually take all 24 of those devices and create a new account. And now we have the ability just to move everything smoothly over to the next person. But we need that documentation to support that, because we do get audited on occasion from the Auditor General saying, okay, show us proof that, this change of license occurred, this change of ownership occurred, things like that, to comply with statutes related to licensing. So. And then let's see here. 203, not much has changed, just removing some outdated language. There is one thing here that it wasn't called out clearly. It wasn't our rules before, but basically, if your commercial device has a stop use tag or an out of service tag, a person shall not use that device until it is repaired as ordered by the division. So again, that corrective action notice. And typically that's correcting the violation that we note on the inspection report. The commercial device has to meet all of the requirements of our statutes, our rules, and Handbook 44. And that's a big one, because a lot of times if a device just needs calibration, for instance, or that's the only violation we find, a technician will come out and they'll only repair that violation. But before they leave that device, they need to make sure that everything else about that device is compliant. Because one of the things that we're doing now is we're going out and following up on enforcement tags that we issue. And so we'll select a random group of tags, and if it's a red tag, yellow tag, whatever, and we'll go out and make sure that that device is repaired, and we'll actually retest it. And if we retest it and find that, hey, something else is wrong with it, or that original violation isn't corrected, then, we're going to be going to the person that repaired that device, possibly with a violation, because it wasn't repaired correctly. So you need to make sure that when you're going out to a device, if you're repairing that device, certifying that it's accurate, that it meets all the requirements in our statutes, rules, handbooks, that it really does meet all those requirements and it's good to go. Because if we go back and find that it's not, enforcement action may apply. And that is a requirement as a registered service representative that's existed for a long time, but we're calling it out here just to emphasize it again. And then if you sell a commercial device for some reason that has one of our tags on it, maybe you didn't want to repair it, you're going to sell the business, you're giving up on that device, whatever, you find somebody else that wants it, you can't remove the tag, and you must disclose to the buyer that that device is not in compliance. So if you're selling it to somebody else, you're saying, hey, weights and measures, when they last inspected this device, it was in violation, disclosing that it has those issues. Because if the next person places it into service and we go out and inspect it and it has the same problem and they didn't know about it, it's not necessarily fair to them, although they should be proactive in making sure that their devices are installed correctly and accurate and so on. So That is just called out separately here. We haven't ever run into a situation where that's happened yet, but it is possible for the resale of those devices. And then the livestock scale section that was repealed because all of these requirements are already in Handbook 44. So livestock and portable scales, clearance requirements, portable scales need to be portable. I always thought that rule was funny. Those are already requirements that exist in Handbook 44, which we adopt. Any questions so far? I know it's a lot to go through, trying to make it as brief as I can, but we have a pretty extensive section in the administrative code. This one here, 302 was updated, the title just to clarify what the section's all about, packaging, labeling, and method of sale. So this is where Handbook 130 and 133 come into play. But people don't typically know what Handbook 130 and 133 are. So we're saying, hey, packaging, labeling, and method of sale. That's what this section is about. And in section C here, if we find a package that's short weight, for instance, one of the things that we'll do is we'll place it off sale, but a retailer can then correct the package, or a packer can correct the package by one of these four options below. So they can remove the package from sale completely. A lot of times that'll happen. If it's something that's packed in-house and they can relabel it, they can do that to reflect its net quantity and put it back on the sales floor. They can place a notice on the package saying, hey, this package doesn't meet the labeled statement here, but we've priced it accordingly to reflect the net quantity. Or you can repack the commodity completely so that the package contains the net quantity represented. So an example of this is if we go into a grocery store and we find that a package of chicken, no tear was taken off of it. Well, one of the things they can do is just relabel it so that the tear is represented on the package and deducted from the gross weight to reflect the correct net weight, or they can repack it all together. Sometimes you have to do that because the gel soaker pads and things that are in the packages, it can be messy just to try and get the tear value again. So those are options so that that item is still able to be on the sales floor and go out to a consumer with the correct net quantity represented. So that's what these are. And we've had those in our rules for a long time, but I just want to emphasize them as, hey, those are some options if we go out and do a packaging inspection at your location. We'll try to work with you to get that package back on the sales floor if it's possible. Sometimes it's not, sometimes it is. And then moving on to retail pricing. So here's where that new term comes into play: retail pricing, retail price inspections. This just talks about our retail price requirements. So down below, these these were moved from 302 for whatever reason. They were in section 302, but they're really meant to be in 402, where we're talking about retail pricing. So it just explains some of the things that if you have a commodity for sale, this is how you need to price it, or these are the options you have to price it. It clearly defines what an initial retail price inspection is. So this is one of those where we go out, say it's a brand new business, brand new location. First time we're there, what we're going to do is an educational inspection. So it says the initial retail price inspection of a location is for educational purposes, and administrative enforcement action will not be imposed for a violation identified during that initial inspection. So we go out, we test our 25 or 50 items for price verification, our 125 or 250 items for price posting. Maybe we find a problem there. We're walking hopefully with the location representative and educating them along the way and saying, this is how you can post prices in this situation. This is why this one's a violation. And we're giving them a chance to learn about the requirements, get their location on track before we come back and do a reinspection. And so the results of that inspection will document, hey, you didn't pass the inspection, but there's not going to be any enforcement action taken. Basically, this is your one chance to correct things. When we come back after that, then our regular enforcement structure will go into play. And so a lot of times these inspections are great because it gets us a chance to develop that relationship with the location. And like I said, educate them on what our requirements are. Because a lot of times people don't know, especially if it's an independent business, that there are certain ways you can or cannot post prices and that you have to have prices posted on everything. So anyway, and then it continues to say an initial inspection is the first retail price inspection conducted at a location when no prior retail price inspections have occurred at that location under the current ownership. So let's say you have a convenience store that changes ownership. Well, the inspection history that happened under the previous ownership, it's still documented in our database, but it's no longer relevant as far as our inspection pattern goes. So now what we're doing is we're restarting with that educational inspection, and we're going to go through and make sure that location's on track, and then, you know, implement our enforcement structure after that inspection if a reinspection occurs. So again, that one chance to learn about our pricing requirements without having to worry about any violations or things like that.
Quick question on that as
Yeah.
well, Kevin. Does the current ownership or new ownership have the ability to see those prior inspections since you have them on file? Can they ask for those inspections to see what even though they're not being held to them?
You certainly can. Yep. You can go into our inspection database and search by address. So you just look up that same address and you can see the inspections done under the previous ownership, location names and such. Yes, you definitely can do that.
Kevin, I apologize, back up one section. I just have a stupid question. When you're doing your inspections at a grocery store, say, and you're in the potato chip section, and you have a massive number of potato chip bags, and you find one that is off, how do you guys handle that? Do you take the one item off sale, or do you things that are packaged in mass quantity? I guess I'm saying if it's the potato chip bag contains 2.5 ounces, but you come up with 2, do you take all the Lay's potato chips off sale, or how does that work?
Well, there's two ways that it could work. One is that if you have a package that exceeds the maximum allowable variation. So in Handbook 133, it says for packages that are between this, these weight values or these values of volume, this is how much you're allowed to be off by. It's similar to a tolerance for a fuel dispenser or scale or things like that. So just throwing out numbers here, if you have a package that's labeled by, between 1 and 2 ounces, it might be able to be off by like 0.08 of an ounce. And if you have a package that is short more than 0.08 of an ounce, that individual package then could be placed off sale and the rest of them could remain on sale. However, when we do our test, we're inspecting a lot of items. So typically a minimum of 12 items we're testing. And when we do that, if the average of that lot also, the standard deviation of that lot also goes below the maximum allowable variation, that entire lot could be taken off. So you could have an instance where none of the packages exceed the MAV individually, but when you test them as a whole, maybe 8 out of the 12 packages are short weight. And so in general, that packer is packing the item short and the consumer's at a disadvantage. So predominantly that lot is in favor of the packer. We could place the package off sale that way as well. So there's 2 ways that could go about it. You can either have an individual package exceed the MAV, or you can have the entire lot on average be short weight.
So is it if it's, and I'm just using names, Lay's potato chips, if I'm at a Fry's and you find that lot is in violation, does the retailer, is the retailer held responsible, or is it the packer, the originator of it? And do you go upstream to that person, or do you just stick with enforcing at retail? Does that make sense?
Yes, it does. That's a great question. So if it's an item that's packed in house, going back to my example of like the chicken breast that's packaged at the meat counter and then it's put in the cold case for sale, that is something that would go back to the individual retailer wherever the item is packed. the violation would go back there. But in the case of a bag of potato chips that's packed in a factory, somewhere else outside of the store, the violation goes back to that packer. So if it's just using a name Frito-Lay, for instance, then we would go back to Frito-Lay with that violation. And that's one of the reasons that all of the packaged items have to have the company information on them in one way, shape, or form. It's evolved over the years. Now you can just have a web address that leads you to the contact information for that particular company or packer or whatever. But that's why when you see on those items, it says Dr. Pepper 7-Up, Plano, Texas, or whatever it is. That's the information we use to contact them. And chances are, we have our network of states, different regulating agencies that we work with. Chances are somebody has worked with them in the past, and so we can find the right channels to contact that company and resolve that violation. But yeah, it'll typically go to the packer if it's not packed at that particular retail location.
Thanks a lot. Sorry to slow you down, but really.
No, that's a great question. And one of the things that we also would like to try to do in the future is for items that are packed in Arizona, one of the best places to go and do a packaging inspection is at the actual packing facility, because you catch those items before they go out into retail. You have a larger sample size of items to make sure that the packing procedures are working properly, and you can see the packing procedure happen right before you. So you can help identify, like, if there's a scale or some type of measure that's being used that's not accurate. Or we had a case one time of glazed shrimp, and unfortunately we couldn't go to the packing facility because it was in another country, but they were putting too much glaze on the shrimp, and the way that the machine was designed was that it was assuming that the layer of glaze was going to be X amount of weight. So then whatever other weight was added in was the actual shrimp product. Problem was they were putting too much glaze on it. And so it was thinking, oh, I'm already at my, level where the package should be, when in reality, there wasn't enough shrimp in there because more of the ice was taking up that weight value that the machine was looking for. And so that was an interesting one. And it was just isolated, I believe, to one packing facility that we found. And I was involved in that in a little bit. If you ever tested glazed shrimp products, it's not an easy thing to do. You have to deglaze them, and there's a mesh strainer and a sieve and all this kind of stuff. But yeah, so that's an example of where, somewhere along the packaging line, a machine and the equipment just isn't calibrated properly, or it's spraying on too much glaze, or whatever the case may be. And it's not necessarily intentional, but it's identified through that. One was a complaint that we received, and it was actually somebody who, they would buy frozen shrimp for parties, and they realized, normally I buy 2 bags of this and it gives me this much shrimp, and this time I don't have enough. And it was just an eye opener for them. And we went out and said, yeah, it looks like it's short. So
I have a follow-up question. Does the retailer then have the options to repackage, relabel, and all of that, even though it is owned by, we don't have to wait in a quarantine status until that violation to the outside company comes back?
It's really up
to the retailer at that point to.
Yeah.
Okay.
Yeah, it's up to the retailer. Sometimes what we'll see is the retailer will just reject the lot altogether and say, oh, we'll contact the distributor or the packer directly and let them deal with it.
And we have that option to do that. And okay.
But it'll be off sale. So you have to keep it off sale. But then sometimes the retailers say, we can just relabel it or whatever and put it back on the shelf. That's no problem. But most of the times we'll see the lots, they get rejected, and the retailer's working with the packer at that point. All right. So continuing on with pricing here, price verification, it defines what the violation is, and it's basically if you have more than one overcharge in an inspection, you have a violation. So an inspected location shall be found in violation if more than one overcharge is recorded in a price verification sample. It used to be a percentage, but it would vary depending on if you did a 25 or 50 item sample, and we always allowed overcharge. So here, we just made it easier to understand that it's more than one overcharge, you're in violation, no matter your sample size, which is the way it was before. It's just more clearly defined. If you have an undercharge where it scans lower than the posted price, that's not a violation. And that's the way it's been in the past. So price posting, this part doesn't change. The violations are the same. So if you don't have a price posted or displayed for an inspected item, less than 98% of the items sampled have a marked or posted price, or a percentage or quantity discount is provided, but there's no price displayed for the item on which the consumer may calculate or compare the discounted price to the regular price. Those are all violations, and those aren't anything new either. They've been there. We just moved them down to this section. And then down below, it goes through our violation exceptions. So there are some exceptions where you don't have to have a price posted. I'm not going to go through those today, but that's what this section is all about. So you can look at it and go, oh, hey, does this particular, this item's in a display case. Well, then it doesn't need to have a price posted because, you need the assistance of a sales associate to get it, things like that. All right, Public Waymaster, I'm not going to go through because we really didn't change any of the requirements, just clarifying some things in there. And again, with the licenses, there's that 30-day requirement. If you're a Public Waymaster and you say you work within the same company, you can actually move to a different location, but you need to notify us within 30 days before you move to that next location. One of the reasons that's important is because not only do we then know where the Waymaster's gone to, but if they moved and left all the deputy Waymasters that they had behind and there's no new Public Waymaster there, then that location technically can't perform Waymaster duties until a new Public Waymaster is put into place. And we've run into that issue recently where Public Waymaster's gone on, they've left the company, the deputy Waymasters are left behind thinking, oh, we can continue to do our thing. Well, no, you have to have a Public Waymaster overseeing those deputies, and if they don't exist, then the deputies can't perform their duties either. So, all right, so we'll scroll through here. Article 6, nothing's really changed in here. Those new terms, field calibration standards and vapor recovery test equipment, you'll see those throughout. Just striking over the different terminology that was used before. Our applications for registered service agencies, everything needs to be pre-filed with our division, including if a registered service agency wants to, let's say they don't have their own standards, field calibration standards or test equipment, they can use the field calibration standards and test equipment that are certified under another registered service agency, but they have to pre-file that information with us in advance. It can't be, we discover later on out in the field that an RSR is using, a field calibration standard belonging to company B, and then they say, oh, well, I have permission to do that. No, that doesn't work. You need to have that pre-filed with us saying, hey, so-and-so's given me the permission to do this. That way we have it on file. And if we go out and check serial numbers or look at things like that, we can go, okay, yep, this is certified through our lab. You do have permission to use it. You're good to go.
Real quick, as far as that goes, is that the responsibility of the RSR using the device or lending the device?
Using the device.
Okay.
So yeah, we had an instance where there was a scale company that they didn't have any certified equipment on file with us, and then they later on said, oh, well, so-and-so said I could use, this test equipment. And at the time, that pre-filing part wasn't in there. And so we just kind of took their word for it and, found evidence later that they are using that equipment certified through the other company. But we said, we need to know ahead of time that you're using that, because otherwise it could affect the RSA or RSR license. They would be invalidated because there's no certified standard on file. And if there's no standard on file, then the license is not valid. You can't do anything within our database. You can't submit place and service reports, anything like that. So we need to know about that ahead of time, not only to help us know what standards are being used out there, but to also help the RSAs and RSRs be able to do their jobs efficiently. So along with that comes written approval from the RSA to use the field calibration standards or test equipment, documentation supporting that they meet the requirements for certification in our statutes, and same with the vapor recovery test equipment, that they meet the calibration requirements in CARB or that are required in our chapter. So we did eliminate this third-party registered service agency section because there was a little bit of uncertainty what the intent of this rule was, but all of these things down below, holding a valid license issued by the registrar of contractors, complying with workers' compensation insurance laws, liability insurance, and so on, those are all things that are looked regulated by other agencies such as the registrar of contractors, the industrial commission. And we added a new section in the rules here that basically we have the authority to revoke a license or suspend a license, RSA or RSR license, if we find evidence that the RSA or RSR is not complying with other licensing requirements set by other agencies, which includes even things like, if you need a commercial driver's license to drive a truck to test scales, or, you need to be licensed with the registrar of contractors. If we find out that you're not complying with other agencies' requirements, then we can suspend or revoke or refuse to renew a license. So that was kind of what replaced this section, but the third-party registered service agency, that terminology is gone. And I think that's about it for this section. The rest of it, there aren't any changes that are significant. Again, editorial clarification type of changes here. Yep, here's that section where it says, obtain and keep current during the term of the registered service representative license all federal, state, and local licenses, and ensure compliance with all federal, state, and local laws and rules, regulations, and policies governing the occupation of a registered service representative. Okay. So then we get into motor fuels. And the one thing I'm not going to do today is go through the CBG changes in depth, because that's kind of outside of my technical knowledge. Our regulatory compliance administrator, Michelle Wilson, she's holding those workshops on April 5th and April 19th to go over those sections in depth. But the big thing to talk about with CBG is that, one, the rule was changed to allow E15 in the cleaner burning gasoline area. So that's a gasoline ethanol blend that has more than 10%, but no more than 15% ethanol in it. Right now, what you typically see in the marketplace is a gasoline ethanol blend with up to 10% ethanol. And then we tried to streamline and simplify reporting and certification requirements where we could for our registered suppliers. So giving them a little bit more room to submit reports to us, or not requiring things like product elections and things like that anymore. So again, I'm not going to go in depth into that because we'll have separate workshops for those rules. But if we go down here, I do want to highlight the changes that were made, particularly in section 704 and 705 here. So these sections relate to price and grade posting on external signs, what we're now calling roadside or other signs, at fuel stations. And then 705 talks about posting that same information on fuel dispensers. So the definition here changes a little bit to clarify what this rule applies to. So it's any roadside or other sign, including but not limited to prices on poles, monument signs, canopies, A-frame signs, or other structures that advertises or displays motor fuel prices and is not connected to a motor fuel dispenser. So if you have a a sign somewhere. It could be a billboard down the highway. It could be an A-frame sign next to the pump or up by the convenience store that is posting prices, advertising motor fuel prices. It needs to comply with this section. And down below, it gives you the requirements on what it needs to comply with. These requirements didn't change from before. They're just organized differently. And then you have the option of either using 5 or 6 here, which is you can display the undiscounted price for any motor fuel product, or if you display the discounted price, you have to comply with these sections here, 6A and B. So some locations will choose to have a cash price or a price if you purchase a car wash, things like that, and they'll advertise that on the roadside sign. It needs to meet these requirements to clearly communicate to the consumer the conditions of getting that price, because we'll get complaints. We don't get them as much anymore, but we used to, where people would see a lower price on the street, they get to the pump, it's higher, and they'd say, hey, you know, they're advertising this product for $3.39. When I get to the pump, it's $3.59. You know, that's not fair. And then we go out there and say, well, you know, their street sign does say cash on it, you know, so it clearly is communicating that. I had one instance one time where we were continually getting complaints on a location because of that same scenario. There's a lower price at the street sign. We get to the pump, it's a higher price. And every time I would go out there, the signs looked fine, you know, and it said with car wash, you get this lower price. And so I was like, I don't see what the issue is. They even had a big sign on top of the convenience store that said, you know, 10 cents less if you buy a car wash. And I'm like, okay, what's going on here? Well, one morning I went out there on another complaint and it was dark. It was like 5:30 or 6 in the morning. And I looked at the sign and realized that the panel that said with car wash wasn't translucent. The light wouldn't shine through it. So at night, the consumers, or early in the morning, they were seeing that and going, hey, you know, I get this lower price. And then they get to the pump, they're not seeing the with car wash part. And that was what the issue was. And so we worked with the retailer to resolve that and say, oh, this is the problem. And part of that is the section B here. The discount conditions must appear immediately next to, above, or below the discounted price and with equal illumination as the discounted price. So that was something that was added in there just to clarify. It used to say clean, legible, and visible at all times. The language was changed a little bit to explain that, hey, you know, it needs to be lighted up the same as the price so that the consumer can see those conditions at all times. So that was kind of an interesting scenario that happened. And then down below, the motor fuel descriptions were kind of scattered all over the place in our rule. And we've moved them into this table here. And so basically what it is if you sell this type of motor fuel that meets these standards, it gives you some of the properties of that particular fuel that defines, you know, a diesel number 1 versus a diesel number 2 or a premium diesel or whatever. Then these are the allowable descriptions that you can use on your signs. So you can call it number 1 diesel, some people would say hashtag 1 diesel, but pound sign, number sign 1 diesel, and so on. So it gives you these terminologies that you can use for the different products. And it goes down into the gasolines, ethanol, flex fuel, and so on. And then E15 is included in here now. And then if you want to use an alternative description, we have a couple that are on file that are approved with us. You need to submit that in writing to our division, and it has to be approved by the associate director. So we'll review whatever name you want to provide the product, you know, super duper fuel or whatever you want to call it. And we'll see, well, does that provide enough information to the consumer so they know what they're buying? Is it misleading at all? And like I said, we've only had a couple of terminologies approved over the years. So,
Kevin, real quick.
Yes.
With the incorporation of ethanol flex fuel, how are you guys handling E85 postings?
So E85 is not permitted on signs in Arizona. So it has to be ethanol flex fuel. The reason for that, and that was actually in our last rulemaking that we did in 2018, I believe, 2017 or 2018. It might have been before that, because it was after January, I want to say it was January 1st, 2018, you could no longer have E85 on the signs or at the pumps. And so we've worked over the past couple of years. Every now and then we'll find a straggler that says E85, or somebody will all of a sudden start selling that product and it says E85. But the reason that we made that change is because we were getting complaints. There was a kind of a niche market of motorists out there that were looking for that higher ethanol content, up to 85% ethanol for their kind of higher performance vehicles. And they filed complaints with us and they said, hey, this doesn't seem to meet that specification. And we found that it didn't. And after doing research, we learned that at ASTM, the specification had been updated for this 51 to 83%, and the term was ethanol flex fuel. And so we wanted to make sure that that was accurately communicated to the motorists who would be fueling. And so that's why ethanol flex fuel was adopted, and E85 is not allowed. In other states still, you'll see E85. You'll often hear the two used interchangeably. We still hear people say, oh, can I sell E85 or whatever in Arizona? And we say, well, you can sell ethanol flex fuel that has 51 to 83 volume percent ethanol and meets that D5798 specification in ASTM. So that's the reason why E85 is no longer allowed. And if we see a sign that says E85 or a product label, we will require the retailer to change that. We shouldn't really have E85 out there anymore. Like I said, we've had some stragglers over the years, but I think we've pretty much identified every station that has that product, and the labeling was corrected where it needed to be. All right, so dispenser labeling, pretty much it has to use the same terminology and meet some of the requirements up in 704. That's what's highlighted here. So 704A3 through 6 complies with the fuel descriptions in 704C. And then there's a few other requirements in here that haven't changed other than, oh, there you go, Mark. There's the old rule where it said sites that sell ethanol flex fuel previously labeled as E85 shall update the signage to reflect the sale of ethanol flex fuel no later than January 1st, 2018. So I was right on the date there. I remembered it from my field days. But now this section says motor fuel dispensers that are used exclusively for fleet sales and other price contract sales. So what we call a card lock site, where it's a commercial fueling location, there's no attendant. The price is dependent on the contract that company has with the retailer. They're exempt from the requirements in A1 and A2, which talk about posting the prices or discounted prices. You don't have to have those prices on the dispenser. You can, but typically they don't, because the price will change depending on what contract and who's fueling there. So even with the state, for instance, we have our scale trucks that require diesel, and we typically go to the high flow dispensers at a card lock site to fill them. The state has a certain contract for a price at those retailers. So it's not posted on the pump for us initially. It'll show up on the receipt when we print it out, but it'll be different for everybody. So there's those exceptions to posting prices on pumps if you're doing fleet sales or other price contract sales. And that's basically it through here. The rest of it for dispensers hasn't changed very much. We reorganized some things here to kind of condense the number of sections that we had, but not really any significant updates. Let's see here, oxygenated blends. Again, a lot of these sections relating to motor fuels, if there are questions about them, our workshops on April 5th and 19th will be the best time to address those. And let's see here. So there is some language incorporating E15 you can see in here now. And all right, I think that's pretty much it. I just want to, in this section here, 717, I just want to reemphasize a couple of things, because we occasionally are still finding issues in the field here. But if you have ethanol flex fuel or diesel, those dispensers have to have nozzles that are a certain color. And those color requirements are in our statute. They used to be written here in the rule as well, but again, repeating things in the statute that are in the rule was something we're trying to avoid. But basically, ethanol flex fuel, you need to have yellow grip guards on your nozzles. Diesel, you need to have green. We're still occasionally finding diesel that's black, or there was one company, their branding had diesel as yellow. And the whole point of this is to try and reduce misfueling by associating that product with a particular color. So that's one thing I just wanted to emphasize really quick. And then the other thing is the motor fuel dispenser filter requirements, which is right up here above in section C. So if you have a gasoline alcohol blend, ethanol flex fuel, you have to have a 10 micron or smaller pore size filter on that dispenser. And then for biodiesel, diesel, and other blends, you have to have 30 micron or smaller. We're still finding some 30 microns on the gasoline dispensers. And we did issue an enforcement discretion last year that expired at the end of November to allow 30 microns on these gasoline dispensers because it was reported to us that there was a shortage of those products or supply chain issues. But we're still finding 30 microns occasionally on gasoline dispensers, and that is something where we'll shut the dispenser down for, if we're finding the wrong filter size on there. So just wanted to highlight those. And then the rest of this, I'm going to really get through the CBG section here. I'm not going to go through any of this. And we'll go down to vapor recovery. And we're almost finished. I appreciate everybody's patience with this. And I appreciate the questions that have been asked as well. All right. Article 9, Stage 2 vapor recovery. Well, it used to be Stage 1 and Stage 2. We repealed this section because Stage 2 vapor recovery is prohibited under statute. So there was no point in having this. It was actually recommended that we get rid of it, but none of these rules applied anymore. So this whole section is gone, and you won't see it. All you'll see in our new rules in the administrative code is Article 9, repealed. That's all it'll say. And so all of these sections, 901 through, I believe, 913, they're all gone now. And then what applies to vapor recovery is Article 10, which has been around since we started decommissioning Stage 2 vapor recovery. One of the biggest change in here is that there's a new test requirement, the static torque test for the rotatable Stage 1 adapters. That's a new test requirement that we're going to implement. We're not doing that right away because I believe in July is when we're planning to have our vapor recovery registered service representative class. It's coming up on that 3-year mark. Once every 36 months, our vapor RSRs need to go through a certification class and take an exam. And at that time, we're going to talk about implementation of that new static torque test. So that is a requirement here. We're not going to require that quite yet, but it'll be something coming along later this year. And it's to make sure that those rotatable adapters, they aren't coming loose and allowing vapors to come out. That's the purpose of the test. So we've been working with CARB on ensuring that that we have the test procedure, we understand it properly, we have the proper test equipment to go out and do a demonstration of it, and know what we will need to require from the registered service agencies going forward. And then I believe that is pretty much it here. Yep. Okay, and then the last page here that you don't see in here, but there's a table for our pressure decay test, the allowable decay rates for the different ullage of the tanks. That's the last thing in Article 1 that's a table, but it wasn't submitted in our notice of final rulemaking because we didn't amend it at all. So that is our summary of our rules. I know it's a lot to go through, but we are done with that now. Okay.
Where could we see that posted?
That's a great question, and I'll actually show you here. Let me share my screen again. So it usually takes the Secretary of State's office a little bit of time to update the administrative register and the administrative code to reflect the rules without all the strike throughs and all that information in there. But we have added it on our website here. So we added a new page here. So if you go to agriculture.az.gov, at the top, weights and measures, there's a page, statutes, rules, and references. And so this page, you click on it, it'll give you the current edition of everything that we adopt in our statutes and rules. So right here, statutes and rules effective March 5th, 2023. It'll be an unofficial version, as we call it. It's not, all nice and pretty like the Secretary of State's office does. We have the administrative register here. This is where our notice of final rulemaking was published. It highlights the changes from our previous rules. And then the official rules eventually will be published on the Secretary of State's office here. And then statutes, you can always go on to the legislature website and look at that. And then our handbooks down here. The nice thing about the NIST handbooks is not only do you get the current edition, but they'll have the PDF files for all of the previous editions that ever existed. You can go back and pull those up, which is helpful for us because we never seem to quite adopt the most current edition. And so you can go on there, and these are nice because if you're looking for a specific thing, you can do the Control F. They're searchable PDFs. They have the text recognition, and you can look for specific terminology and find them there. So everything that we have is now listed in one place. So if you ever have any questions about our statutes and rules or need a copy, just go on to this webpage right here and you'll find what you need.
Kevin, quick question. You mentioned a regulatory bill of rights. Is that also listed in those files?
The regulatory bill of rights, we do not have posted. I believe the general part of it needs to be posted on our website. I've got to find where it is, though.
No problem.
We're happy to provide a copy of it. One of the reasons, like I said earlier, it seems to change every year. There's two sections of it. There's one that applies specifically to the agency that's doing the inspection. And then there's another section that's the small business regulated small business bill of rights or something like that. And that is specific terminology that's required under Title 41. We can always provide a copy of that upon request, just to show you what it is, because it's a lot of information to go through and review. Typically when we present it during an inspection, we may hit some key points on it, but basically we'll say, please review this, and if you have any questions, let us know. Because it does explain your rights during our inspections, but it's a lot to go through, and so we like to give you the opportunity to look at it and make sure you understand. So I don't think we have it posted on here. I can look into seeing if that's something we can post. We have to be careful about what we post now because there's a requirement. There's a statute that was passed last year that prohibits us from posting any policies or things like that on the website if our statutes or rules don't require them to be posted on the website. So basically, we used to have our enforcement action policy, our civil penalty policy, because that's not required by statute or rule to be posted on the website, we had to get rid of it. So things like reference materials, statutes and rules and so on, we can do that. But yeah, if you want a copy of the Bill of Rights, I'm happy to email one to you.
Request it via email.
Yeah.
Okay.
Yeah.
Thank you so much.
All right. Great questions today. Okay.
One more question. On the presentations and the meetings that Michelle's going to do, will that be open to our members so they can go online and go through the workshops?
Absolutely. Yes. If you, the question was, for those that may not have heard, for the workshops for motor fuels that are happening in April, they're open to anybody to attend. And if you did not receive the link, we only sent it to the people we think would be most interested, who were signed up for our motor fuels distribution list and our registered suppliers. But if you want to attend, you're more than welcome to, and we can send you that information. Yep. Okay. I believe we're ready to continue on.
Okay, we'll go on to number 5 on the agenda. Council meeting thoughts for future strategic planning. I'm going to turn that back over to Kevin.
All right, I'm just getting ready to write my notes here. So one of the things that we're preparing to do, and we do every year when the new fiscal year comes around, is strategic planning to make sure that we're setting goals to help our agency, our divisions, and our department improve and carry out our mission as effectively as we can. And so one of the things that we were asked to do this year is go to our advisory councils and our stakeholders and see if there was any feedback on things that might be able to be incorporated into our strategic plan. And so this is just an opportunity for our council members here today. If you have any thoughts on this, I'm happy to take those ideas down and take them back to our leadership team here in agriculture. We do have somebody who's dedicated to strategic planning now. Her name is Heather Flowers. She does an awesome job trying to keep us on track and set meaningful and challenging goals for our agency. So I'm welcoming any feedback if anybody has anything.
I definitely have some. You mentioned the motor fuels and clean burning gases having a workshop. I do believe that in the cannabis industry, we would benefit from that as well. With all of the new changes in ownership and the new dispensaries that are coming around and new inspections that are happening. I know that colleagues of mine have asked for some more information coming to me personally. In pushing towards the website, it's wonderful. It's very informative, but I think an open forum for questioning is very helpful.
Okay, and one of the things that we are trying to establish in Weights and Measures is a task group for cannabis, where we have, it's kind of like an advisory council, so to speak, but it's more informal, and it's a forum for industry members to communicate with us and back and forth about requirements that may be developing, expectations during inspections and things like that. And our compliance manager, Vince Wolpert, is working to do that. Hopefully that's a goal for the next fiscal year that we can try and implement. But one of the things that I see from that, not only for a specific industry, but maybe a goal for our agency, because all of our different divisions, we regulate somebody. We regulate some industry, and sometimes we regulate the same industries. And having regular workshops with those different industries and with our stakeholders as some type of measurable goal for the entire department, I think would be beneficial. So, and the way this works too, just to let you know, is there are goals that come up for the entire department, and then each division's required to develop their own strategic scorecard metrics. And so that could be a good scorecard metric for Weights and Measures, for instance, is to establish a regular cadence for different industry groups to have those meetings. So that's a great suggestion.
Kevin, if I can interrupt real quick, we've got an emergency here. I've got to bug out. But just piggybacking on that last point, I would encourage the whole stakeholder process to maintain that, because it's been a wonderful thing over the years. And as you know, with new administrations and new directors, that might not be carried on. So I just wanted to chime in on that the stakeholder process is a wonderful one. It includes all those stakeholder meetings and and whatnot. So I would encourage keeping it. So got to bug out. Sorry about this.
All right. Thank you, Mark.
All right. Take care, guys.
Okay. Any other feedback?
I would just say from the kind of vapor recovery perspective, if there is going to be the additional testing requirements, any kind of outreach or education to the stations themselves, updating them on those kind of regulations and requirements is always helpful, from the RSA perspective, and allows them to also understand the difference in some of the updates as far as that goes. I know that like you said, it goes out as far as these stakeholder meetings, but maybe some more focused potential updates on the regulations for that specific industry, or whether it's Class A operators or however it may be, I think would be helpful.
Okay, yeah, that's a great suggestion. And yeah, we definitely don't want like a RSA to go to a station and say, hey, there's this new test requirement, and the station's like, yeah, we don't believe you, kind of thing, right? And
It's an extra $150.
yeah,
That changes things quite a bit.
yeah, we definitely want to try and keep those relationships between the RSAs and their customers as positive as possible. And I kind of see that, that's a great suggestion. And I kind of see that how we communicated with decommissioning back in the day to the different locations, sending out letters and possibly inviting people to a workshop there to ask questions as well. So.
And then the other one thing is I don't know if it's necessarily it applies to any kind of rules, but there's been some potential an update on the cancellation policy for the stage 1 vapor recovery. There's been just some issues, throughout the year. I think, with just the communication with the inspectors and the agency and the RSRs. And I think that, that might be something that, we could work together to improve, maybe a general, inspector/RSR email for cancellations or something along those lines. I've spoken with Damian DeSantiago on it, and we've had some discussions on some possibilities. But I think that might be something that could just, help, kind of free up and maybe logistically for both the RSRs and the investigators, as far as some of the stage 1 testing and cancellation policies.
And I think that, yeah, I've definitely noticed over the past maybe year or two that there's more cancellations. But I think that would be a great thing to address when we have that RSR training in July, because our inspectors will be participating in that as well. We're requiring our inspectors now to go through that same training. And so I think that would be a good thing to bring up, among other things. So
yeah, it's one of those things, just from, at least from, some of the station's perspective, fuel deliveries and stuff can be super sporadic. They can't guarantee fuel times or anything. So we have been running into a lot of issues with, ullage requirements and fuel delivery, either, coming too soon or too late, that, lead to some of that. But like I said, I feel like, a combined effort between us, RSRs and the agency, might help, at least, with some of the logistics of, freeing up your inspectors as well, if they don't have to go to into the inspection as well. So
I'd like to piggyback on that. Is there a way for us to invite our specialist, Vince Wolpert, for instance, to host, and the RSR or the industry can host the training and fund the training and stuff, and invite our inspector to come in and speak at that training? Are we allowed to request him to do that? And would that be a part of that?
yes, absolutely. So before we get to that, just going back to the cancellations, I agree with you 100%, Eric. And, one of the things that it creates an issue for us is our inspectors take the time to travel out to a location, and then the inspection doesn't happen.
Exactly.
And it's time that we could spend doing other things. And that becomes challenging, because one of the big issues that we face and seems difficult to avoid is travel time for us. And so depending on the work schedules of our inspectors, where the test site is, they might have to travel, an hour across town to get there, and then hour to get back into their district. That's 2 hours that we could have spent doing something else. So not only is it a challenge and an inconvenience for you and other folks in the industry, but it's also for us. And so, yeah, we definitely have identified that as one thing to address. For Leah, as far as your suggestion, the biggest thing that we like to do is educate, try to get out there ahead of the compliance issues so that they don't happen. And so if there's an event that that's going on where there's a lot of industry members together that we regulate, and you need clarification or you just want an explanation of, hey, what happens during inspection? What are the requirements that are expected of us? We will absolutely try to accommodate all requests to go out and talk and answer questions. We find that to be one of the most effective ways to work with industry to prevent noncompliance from happening, because when noncompliance happens, it's an inconvenience for everybody. It creates more work for everybody, right? And sometimes people they don't know what the requirements are that are expected of them. So yes, and that goes not just for the cannabis industry, for any industry that we regulate. If you want to learn more about our inspections and have somebody come out and discuss the requirements, go over the handbook, whatever we need to do, we are always open to doing that, and we will find the time to make it happen. So yes. All right, these are great suggestions. Some of these I don't see as like a department level thing that can be implemented, definitely at the division. But this is helpful feedback regardless, because it can give us things to focus on for the next fiscal year. So, yeah.
Do you treat CBD differently than you do products with THC? In other words, when you go in and do an inspection in a convenience store, grocery store, and they sell CBD, are there any special requirements for that? Or is it just because it doesn't have any THC in it, it's not part of your cannabis program?
So the question was about CBD versus products that contain THC, cannabis products. For us, we treat a package as a package, right? And if there's a label quantity statement on it, if this contains, if it's a bottle of water and it says, okay, it contains 1 liter, then regardless of what type of water it is, what the water actually contains, if it has electrolytes or grape flavoring or whatever, we're still going to test it to, it needs to contain 1 liter. And it's the same thing when it comes to any of those products out there in the marketplace. There may be differences in the test procedure. Cannabis may be called out specifically versus products that don't, contain that THC level, and it depends on how it's defined in the handbooks at NCWM. But yeah, we would look at it as it containing the quantity, the weight, the volume, things like that. As far as the actual content of the product, does it contain whatever types of I don't even know how to explain it, but like I said, electrolytes or grape flavoring, if it says it contains 10% juice, we don't get involved in that. We're just looking at the basic weight statement.
If I'm allowed to, I can piggyback. We are regulated by a different division,
Yeah.
AZDHS. So Arizona Department of Health Services tells the industry if you are allowed to sell THC or certain amounts of CBD. And as soon as you are at a certain amount of THC, you must be regulated by AZDHS and be licensed to do so.
Thank you.
So different division. Yeah.
Yeah, there is somebody out there checking on that, but it's not us. I guess I should have said that first. But yeah, sometimes people see things and they, we have a definition in our rule now of net quantity, and that's the thing that we focus on. But it tells you what net quantity is, and sometimes people think, oh, it's the quality of a product, or something like that. And we generally don't get involved in that unless it's like a motor fuel, then we do. But
I do have one more. You mentioned again the National Conference for Weights and Measures, and before you had mentioned that the cannabis industry is being talked about much more. I'm sure. Higher level, would there be a way for our industry locally to partner with whoever is visiting those meetings? And I'm sure that's what the task force is probably being invented for. What would your suggestion be of us to best partner with you guys as a division?
My first suggestion would be to reach out to NCWM and get a list of members, because you might be surprised at who's a member in NCWM. And that's a public list, I believe. Yeah, it's a public list. And you might know somebody that's already a member, and they can kind of reach out to you and keep you informed. For us, our compliance managers, part of their job is to make sure that we're involved and we have a voice for the state of Arizona in NCWM. Surprisingly, there are some states out there that really don't participate and they kind of go and do their own thing, but we find it's more beneficial to have that voice and say, hey, this is what we're finding in Arizona. This is what we're finding in New York or Florida or Iowa or wherever, and come to an agreement on that with industry. That's the beautiful thing about NCWM, is that industry has a voice as well. And so when it comes to voting, when it comes to talking about the amendments made to the different handbooks, people have an opportunity to go through and explain their perspective and what would work best for everybody. Sometimes people come to agreements. Most of the time they do. Sometimes they don't. But in the end, at least you're informed about what's going on there. And so giving like the electric vehicle charging stations as an example, making that tentative code permanent. All the companies out there that install the chargers, make the electric vehicles, they were all present, having a voice in that. And so yeah, and you can always get involved on your own. Membership to NCWM is not expensive. And they have 2 meetings a year right now. But like I said, I would look at the list of members first. And second, then I would reach out to Vince Wolpert, our compliance manager, and he can tell you what's happening as well. Anything else?
No, I just think I know in previous meetings, I think that the risk-based inspection process. I think that sounds like a good way to kind of prioritize things, and obviously the cross training that you mentioned, I think is valuable to the agency and the consumers as well. So
yeah, and I'll actually talk about that here in a little bit. But anything else related to strategic planning or just general feedback? Okay. Then I'll move on to the agriculture and weights and measures updates. So I put AZDA in here for updates because, yes, we currently have an interim director. So our director, Mark Killian, he resigned last month. We were sad to see him go. He served our agency for 8 years and I think brought us into a much better place than we were before. And he was the director the entire time that weights and measures had been with agriculture. So it was the only way I knew it, so it worked well for us. But our deputy director that worked with Mark, Jeff Grant, is now our interim director. So the governor's office has appointed him as interim director for the time being. And that's great because Jeff knows what we've been working on in the different areas of our department, knows our strategic plan, knows the direction that we're trying to go. And he's trying to keep us heading in that direction. But the governor's office will likely appoint a new director at some point. And the way that they typically do that is they'll have a committee, a selection committee, that will review different candidates and appoint who they feel is the best fit, for our agency as well as the goals of the new administration that's at the governor's office. So it's a waiting game right now. It may take a little while, but for the time being, Jeff is still with us and he's leading us, continuing on and trying to lead us, and he's doing a great job of it. I know he has a lot on his plate now. So that's the update for agriculture. And so on our documents, yep, you'll see interim director Jeff Grant for a little while. And that's what's happening there. All right, for weights and measures, the biggest news, the upcoming next week, is our Weights and Measures Week events. So we've resumed Weights and Measures Week events this year after a 3-year hiatus due to COVID and having challenges getting schools able to go out and do field trips. But this year we were able to work with 4 schools and 4 grocery stores and retailers to hold Weights and Measures Week events. And so the calendar of events is next Monday, March 6th. We have an event at a Fry's store in Tempe at Guadalupe McClintock. And so we'll have elementary school students attending Weights and Measures Week events there. March 7th is a Walmart store here in Phoenix by the old Metro Center Mall. We'll have Weights and Measures Week events there on the 7th. Wednesday, the 8th, is Yuma at an Albertson store in Yuma. And then Thursday, it was supposed to be tomorrow, but it'll be Thursday, March 9th, is at a Safeway store in Williams. So we try to expand our events across the state as best we can. We tried to have an event in Tucson, but it just didn't work out in time with the school. So we'll shoot for that next year because we have a regular location and a Food City store that we usually work with down there. So we're looking forward to the events. And what happens at Weights and Measures Week events, for those that don't know, is we invite school children to the store, and we have different stations where we demonstrate weights and measures and how it applies in real life applications within the grocery stores. And we try to align it as best we can with the curriculum that the students are learning with science and math and measurement and things like that. And so it's a lot of fun. The kids, usually enjoy it quite a bit. And we hope that they learn something from the events. But we'll have 4 stations this year. We have one on motor fuels. The inspections that we do, we actually have a full door of a gas pump that we'll set up, and we'll go over that, and we'll demonstrate some of the things we do to test pumps for accuracy and things like that. And we'll talk about measurement and volume. We have one station that we talk about the equipment that we use for testing scales. We talk about packages. What is tear? We're going to do some exercises as far as basic package inspections with the students and see if they can figure out which one has the right quantity and which one doesn't. Of course, we're going to stage those. We're not going to use actual packages. You never know what you'll find sometimes with those. And then we have a station for price accuracy. So up at the register, we'll have items that have prices marked on them, and we'll see if they scan correctly at the register. The kids love that because they get to move the items across the checkout counter and hear the beep and see the price come up. And we'll talk about products sold by weight at the register and how that works, how it computes the price. And then we'll have a station on price comparison. So out in the produce section, we'll talk about buying items in bulk. We'll talk about buying items by the each versus items by weight, and how to determine what is the best value for you, and do a little demonstration to show students when they're out with their families. Uh-oh. There we go. Computer was going to sleep. When they're out with their families, shopping, maybe to help their parents find the best value or what works best for their family. Some people like to buy the pre-prepared packaged products. Other people like to do it themselves. And so it should be fun. And we'll try to have as much of our equipment out there as we can, as far as like we've had our big scale truck out there before. We've had our propane equipment out there before, just to show people the different types of equipment that we use, the small milligram weight all the way up to the 1,000-pound weight, and, the variety that we have, and give them a history of weights and measures as well. It started in 1799. President Adams signed the first weights and measures law to help standardize units of measurement here in the United States and make sure that commerce was happening fairly. So it's a lot of fun, and we go way back in history, and it's an event that's celebrated across the country. Weights and Measures Week is the first week in March 1st through 7th. So other states hopefully will be doing the same. So Weights and Measures Week, again, that's happening next week, March 6th through 9th. Eric mentioned the risk-based inspection plan and the training that we're doing. So right now, where we are at with that, we just completed training some inspectors in Public Weighmaster. So we have 8 inspectors trained in that now, so they can go out to the different truck stops and vehicle scales, places where commodities are weighed, and make sure that they're being weighed properly, and that the weight certificates are being produced properly, so that nobody gets in trouble out on the road when they're traveling down the highway. The next category that we're going through and retraining on is retail pricing, and that should be done fairly soon, by the end of the month, as well as motor fuel quality sampling. So we no longer are using the Zeltex analyzers. We've had too many challenges keeping those calibrated, and they seem to be affected by temperature quite a bit. So we're no longer using those as a screening tool, and we're just focusing on sampling for laboratory analysis. And so for the 2 labs that we work with, the one sampling procedure hasn't changed, but the other lab that we work with that's actually out of state, they've supplied a new sample container for us that we need to train our inspectors on. And so we'll do that. And so that will lead us up to the end of March as far as training. And then the next training program we have is packaging, which is going to take a little while because packaging covers such a broad spectrum of products. And so you'll probably see us out in the stores doing some packaging tests and audits. We're just focusing on training our inspectors there. And we're still planning to implement the first part of our risk-based plan in the new fiscal year. So it's a lot going on. We were recently, the Auditor General recently followed up on us to ensure that we are still implementing their recommendations, and they came back, I believe, and said that all of the recommendations that they made in the regulatory audit are being implemented. So that's a good thing because it means that we're on the right track. If they said, no, you're still not implementing something, then we'd have to go back to the drawing board. So that's where we are with risk-based inspection plan at this time. Any questions on that?
I know in previous we talked about finding an additional investigator in one of the outlining areas. I was just curious if you guys had any luck with that, and then also if you had an idea of what your current headcount is for active investigators.
Yes, you are on the ball today, Eric, because you're leading me right into the next sections here. So my next update is about a new inspector. So we had a position posted in Tucson. We had moved it down there because we were having challenges finding an inspector up north in the Flagstaff area. And we have an inspector who's retiring later this year in Tucson. So we want to pass on some of that institutional knowledge and get them going, because there's quite a large area that team covers, all the way down to Mexico, all the way over to New Mexico, basically over to Ajo and up into the northern part of Pinal County, Maricopa, Casa Grande, and so on. So we do have somebody that we're working on bringing on board. They're coming in from out of state, but the benefit here is they have weights and measures experience. They were an inspector in another state for a weights and measures agency. And so that's great, because we're hoping that'll accelerate the training process a little bit. Most of the time when we bring people on board, like myself many years ago, I didn't know anything about weights and measures. So I had to start from square one. So hopefully this person, it'll be a smoother transition. And they're going to cover, the plan is that they're going to cover Pinal County, so Florence, Coolidge, Casa Grande, Maricopa, and then they're going to go down the corridor to Tucson and cover some of the northern areas, Marana, and so on. And so we tried to make sure that where this person was going to be located in Arizona, it was going to work the best travel time-wise, that they were going to be as centrally located as possible. Again, we can't avoid travel just because we have such a big state and things are so spread out. But I think this will work out pretty well. So we're hoping to bring this inspector on board by the start of April, and that'll give us 14 inspectors and our 2 field supervisors. So we'll have all of our positions filled at that point. And then once we have somebody retire, we'll work to fill that position, probably try up north again, because right now we have one inspector up there who just goes back and forth across the state. And this time of year, it's been really hard for them to even move anywhere. They've been at home a lot because the roads, the interstate's been closed. They can't go anywhere. So yeah. And, you know, as far as getting more inspector positions in the future, we'll just have to wait and see how the new administration, Governor Hobbs and her team, you know, if that's something that they're going to make a priority. But we're pretty happy to have all of our positions filled soon. And, you know, with the risk-based plan, it focuses on the work hours we have available. So it's not going to hopefully make us try and do more than we have the ability to do. So, and that's all I have for updates from weights and measures. Any questions?
Just out of curiosity, when you say field supervisors, is that the same as the compliance managers? Is that Damien and Vince, or is that separate?
So Damien is one of our compliance officers, field supervisors, what the working term is called. And then we have another one, Chad Pillier. So they directly oversee a team of investigators each. So 7 investigators that they have. Okay. And so it kind of, we over the past couple of years, I've tried to create more of a tiered structure so that Damien and Chad can focus on what's happening out in the field, making sure their inspectors are trained, that if they have any issues or need any help, that that's covered and that they're meeting their goals. And then Vince Wolpert's one of our compliance managers for vapor, cannabis, motor fuel quality, and soon, hopefully, electric vehicle supply equipment. And then our other compliance manager is Mike Brooks. And so they're more office positions, and they work with industry to resolve compliance issues, prevent compliance issues, and they also develop the training materials for our inspectors. So everybody has a lot on our plate, and we're all doing, it seems like 5 jobs at once, but that's helped us spread things out a little bit better, because before we didn't have 2 compliance managers, and having one try to deal with everything was just impossible. Even having 2 try to deal with everything, especially, with 17 or 18 inspection programs, it's hard, but we're doing the best we can with it. So, yep.
Okay. I did have one question. You mentioned the training that we're going through for the new risk-based.
Yes.
You had mentioned we'll see them out. Will this be hands-on training in stores that they're doing?
Yes.
Okay.
Yeah, hands-on.
With the price posting and the
So
weight and that kind of thing.
Yeah, the price posting, because not much has changed with that over the years. We'll continue to do those inspections at a regular cadence. There may be some hands-on training out in the field for that. But with packaging, just because of the variety and the complexity of some of the test procedures involved and the equipment that we need to use, that'll definitely be field training. We have had packaging training in the past where we bring in products and we have our scales and our glassware and all of our equipment out there. But it really works best out in the field, doing an actual packaging inspection. And so we have people that have been certified through NIST to do packaging inspections and are pretty well versed in those procedures. And they'll kind of be leading us through that training. And really, Handbook 133 is the standard of work for those inspections. It outlines the test procedures for pretty much everything. And so we don't have to develop much on our own. You just have to educate people. And that's the challenge, because there's lots of little intricacies depending on what the products are. There's some special equipment that you need to have that we have available. And we actually have we're better equipped to do packaging inspections than we have been in the past. We have things like certified linear measures now, and we can test borax. We can do all sorts of strange things now that we didn't have the ability to do before. And we have gotten several complaints from consumers on packaging, items are short weight, that they've been concerned about. So we have been able to practice out in the field. We had one on, I think it was the thickness of leather that was sold, because certain items are sold, at a certain thickness and it's labeled as such. And so we had to discover how to do that. But everything turned out to be okay in the end. But that was interesting. It's always a learning experience with packaging. So yeah.
Okay.
All right.
Anything else?
That's all I have for the updates.
Okay. Then we'll just go out a call to the public here. See if there's anyone out there who, I don't know if we have anybody on. All right, Mark back. Hi, Mark. All right.
Hi, my name is Cassandra Humphrey. I actually work for a medical marijuana facility. We have 11 different facilities in the state of Arizona, and I'm new to this meeting. I'm new to understanding how the Department of Agriculture, along with weights and measures, have been, kind of coming into the cannabis industry. And I'm curious if there is any. So I know you were mentioning that, within the next fiscal year, we are going to develop X, Y, and Z to help understand what we as facility agents are required for, what we are business owners in the cannabis industry for. Would you mind expanding on that? Because I've actually been told that the inspections have been happening already this year, and for me particularly, I've got 3 different grow sites with production facilities and packaging facilities, along with 5 retail locations. So when I get word that you know, we've had these inspections that are lasting 8-9 hours, and there's no kind of documentation to kind of give us be better prepared for these inspections. I was curious if there's any other information other than the NCWM that like that there's information regarding the rules and regulations pertaining specifically to the Department of Agriculture and Weights and Measures.
So that's a great question, and I'm glad you're able to attend our meeting today. My suggestion would be to reach out directly to our compliance manager, Vince Wolpert, with your questions. And you can go on to our website. I'll actually show you here where you can find the information. But one of the things that I found too is that there are different regulatory agencies out there that are inspecting the same locations for different reasons. And so some of them may or may not be our inspections, 8 or 9 hours. It could happen with a packaging inspection, but that sounds unlikely that it might be one of our inspections. I don't, typically they don't take that long. It could. It could be DEQ or DHS or somebody like that. But regardless, for what our requirements are and what the expectations are in an inspection, Vince is the best person to talk to. And he is working, like you mentioned, to develop a task group for cannabis to help sort out some of the challenges that we've found, you know, because this is a new thing, not only for weights and measures to regulate cannabis, for cannabis to be regulated by weights and measures. And so we're both learning from each other at this time and trying to figure out the best way to handle different scenarios, and, you know, waiting for the standards to be developed at the national level. So yeah, I'll show everybody really quick on the call here where you can go and find contact information for particular people within our division. You can always email dwm@azda.gov, but sometimes if you want to skip that and reach out to the direct person, we can do that. So I'll share my screen really quick. We'll go back to our website here. Hide that. And so the best thing to do is scroll down on our homepage, and down here a ways, there's these icons. And so it says, what is the Department of Agriculture responsible for? And you can click on Weights and Measures Services Division, and then there's the contact us information here. So it says who we are. There's my name, so you can always reach out to me. And we go down the line here with who our staff are and what they do. We don't have our inspector individual contacts here, but our management team. So here's Vince's information, and it lists out kind of their main responsibilities. So you're always welcome to reach out to Vince by phone or email, but he'd be able to answer your questions directly. And if needed, you know, we can send a team of our staff out to do an educational visit and just, you know, discuss some of your concerns, discuss our inspection procedure, and go through that. So does that answer your question?
It does for the time being. Thank you very much. I just, like I said, I'm new to this particular part. I've been in the industry close to 10 years now. And when we have certain new regulatory systems, I'm in compliance for this company. So I wanted to make sure that when I'm being asked by staff members or my board of directors or other people along those lines about the Department of Agriculture going on site at other locations and having these massive or dramatic inspections, for me, it's just more of, I would like to gain as much knowledge as I can to be better prepared for it.
Okay, understand. So, yep. Yeah, please reach out to Vince. He'll help you along the way there. And we
Thank you very much.
I believe he will be seeking members for the work group that he's going to have for cannabis.
Okay.
So that's something to think about as well. And you can discuss that with him. So
awesome. Thank you so much for that. I appreciate it.
Okay.
Any other comments? Any other comments? Okay. Moving down the agenda, I don't see any necessity for an executive session. Unless anybody has anything otherwise. No. And I think what we've done in the past for the next meeting is just go ahead and turn that over to Kevin. We're still on a quarterly cadence as far as that goes. So we'll just reach out to the group if that's agreeable to you, Kevin.
Yeah, well, I'll be looking to schedule our next meeting probably in June. And by then, we'll be getting close to our new fiscal year implementation of risk-based. As always, for our council members, if you have any suggestion for agenda items, you want to learn more about a specific area of what we do, please feel free to suggest that for the meetings. But yeah, otherwise I'll reach out to schedule something.
Okay, perfect. And I think we did it last time. I don't think there's any need to move to end the adjourn the meeting.
Nope, you don't need to make a motion. Just whenever you're ready.
All right. Anything else before we go? All right. Thank you very much for your time. Thank you for the information, Kevin. We truly appreciate it.
Yeah.
All right.
Thank you all.
Everybody for attending. Bye-bye.
Kevin? You still there, Kevin?
Yeah, just one moment.